A warm welcome to all attendees on behalf of the Inter-Pacific Bar Association's Investment Arbitration Subcommittee, in short, the IASC. As is customary in all IPBA webinars, we will commence this webinar with a welcome address from the IPBA President, Richard Briggs. Rhonda, could you please play Richard's address?
Ladies and gentlemen, welcome to the IPBA webinar, Investor State Mediation, introducing a practitioner's decision tree. Very interesting topic. I would like to welcome you to the webinar and hope everybody has an enjoyable and thoughtful webinar today. My name is Richard Briggs. My day job is as executive partner of Hadef & Partners in Dubai in the United Arab Emirates. But of course, my other job is as the incoming president of the Inter-Pacific Bar Association, a job which I took over in March from my colleague and friend Jack Lee. Of course, this is the start of the post-pandemic age. Everybody's trying to get back to normal, the IPBA included. We're trying to bring the membership back to normal, and particularly to get everybody contributing to the organisation, to its educational programme, its webinars, and particularly as a lead up to the annual conference in Dubai from 7th to 10th March 2023 next year, topic being One World, Law and the Environment Beyond COVID. So please, everybody who's listening, please come and join us in March next year for our IPBA main event. Return to normal investor state mediation. I'm not an expert on the subject or to what extent the last 2 years have been normal or abnormal. Much arbitration and mediation has switched online to Zoom, to Teams, to other internet mechanisms. And I'm not sure to what extent that's preferable or not preferable. All I do know in terms of organisations and people is that most of us like a little bit of face-to-face interaction, both in terms of the work we do and in terms of the conferences we attend. We have 4 speakers today. We have Nicholas Peacock from Bird & Bird, Natalie Morris from the Singapore Ministry of Law. We have Frauke Nitschke from the ICSID in Washington, DC. We have Santiago Garcia from Freshfields Brockhouse Derringer in New York in the US. And we have 2 co-chairs and moderators who are Lars Muckert of Nishimura and Asahi in Japan, and Kashama Lawyer of Nishis Desai Associates in Mumbai. So everybody who's come in for the webinar, have a wonderful time, and I hope it is both thoughtful and enjoyable. Thank you very much.
Great. I'm delighted to be moderating this session along with my IASC co-chair, Dr. Lars Muckert. The IASC was co-founded by Lars and me in 2018 under the auspices of the Dispute Resolution and Arbitration Committee to make a legal and practical impact in the field of investor-state dispute settlement. One of the key initiatives at the time of formation of the subcommittee was to promote mediation in resolving investor-state disputes, either through introduction of guidelines or collaborations with stakeholders. It is wonderful to see this initiative take form and shape today in the form of draft decision trees for investors and states, a product of able contributions by the IASC's mediation working group comprising Nicholas Peacock, Santiago Garcia, Hiroyuki Tezuka, Nathan Landis, Katie Cho, and Elodie Dalla. The purpose of this webinar is to invite thought and feedback from maximum attendees on the draft decision trees before we can crystallize these into a robust guideline to assist investors and states in assessing the use of mediation in investor-state disputes. Please feel free to use the chat box for your questions and comments through the webinar. We will try to cater to maximum questions during the 15-minute Q&A session towards the end of the session. We have a fabulous lineup of speakers today to discuss and dissect the draft decision trees. Lars, may I invite you to introduce our speakers?
Yes, thank you, Jama. And you will have seen that the IPBA president, Richard Briggs, already gave a very short introduction, but I don't think that does our speakers do justice. So we'll give a bit more of an introduction. And I'll start with Ms. Natalie Morris-Sharma, who is a Deputy Senior State Counsel in the International Law Department of Singapore's Attorneys General Chambers. Prior to this, she served in various capacities, including Director of the International Legal Division of Singapore's Ministry of Law and Legal Advisor to Singapore's Permanent Mission to the United Nations. Ms. Morris-Sharma has participated in and led several bilateral and multilateral negotiations. And interestingly, amongst her roles at the United Nations Commission on International Trade Law, so the UNCITRAL, were rapporteur to the UNCITRAL Working Group on ISDS reform, a role she currently still fills, and chairperson of the working group that developed the United Nations Conventions on International Settlement Agreements resulting from mediation. I also want to point out that she speaks only in her personal capacity today. We have, due to a potential scheduling mishap of the organizers, Frauke Nitschke joining us slightly later. She is a team leader and legal counsel on one of ICSID's case management teams. She has been with ICSID since September 2003. And she not only holds law degrees from Germany and the US, but also a master's degree in organizational psychology, focusing on alternative dispute resolution. And she's an accredited mediator, admitted to the practice of law in the state of New York and Washington, D.C. And importantly, she's one of the big proponents of the soon to be released ICSID mediation rules. Then we have Nicholas Peacock, an experienced dispute resolution lawyer and advocate based in London, where he's the head of the London International Arbitration Team of Bird & Bird. He has experience for over 20 years as a solicitor advocate in complex commercial litigations and ADR, and of course also in the area of investment treaty arbitration. He brings a lot of experience from Asia, having been based in Singapore previously, and he has been heading our working group that has developed the draft decision trees. And then we have Santiago Gatica, a senior associate at the International Arbitration Group of Freshfields Brockhaus Deringer in New York. He received his law degree from the University of Montevideo in Uruguay and his master in laws from Harvard Law School. He's admitted to practice law in Uruguay and New York and has extensive experience in commercial and investment arbitration proceedings, particularly with a regional focus on Latin America and a lot of war stories to tell us later. So much for the introduction to our speakers. Shama, can I hand back to you?
Sure, thank you, Lars. And without further ado, I now invite Nicholas Peacock, who leads the efforts of the IASC Mediation Working Group, to give an introduction into the decision trees.
Wonderful. Thank you, Sharma. Thank you, Lars. Thank you to you and to the IPBA for convening this webinar and indeed for convening the working group. As mentioned, I had the pleasure and privilege to chair the working group on investor-state mediation. It's an interesting topic. I think it's part of the wider debate about making ISDS work better for all parties. How can we help parties to resolve claims and prospective claims without the time and cost of a full formal arbitration or indeed investment court proceedings if we are going that way? This project was kicked off last year in April 2021 under the auspices of the IAC. I should also credit my colleague Simona Peter, who has helped me to chair this session from the start of the working group, and Santiago, amongst others, have been enthusiastic members of the working group. So the first question we asked ourselves in trying to developed the topic of investor-state mediation is what should this group try to produce? What should be our work product? And I think we recognize that this is an interesting topic, and a lot of learned commentary has already been written about investor-state mediation. And what we were keen not to do was just add to the wealth of materials out there, but rather see if we could assist parties, encourage them and enable them to make greater use of investor-state mediation. Now, what do we mean by this? And just standing back for a moment, because I appreciate that pretty much everyone will have heard of mediation and some will have more or less experience of using it. But I think it's also important just to set the scene a little bit. So even those who are aware of mediation in theory may not have engaged in any or many mediations in practice. Of course, mediation at its core is that parties to a dispute engaging the assistance of a neutral third party, or possibly parties, but more often a single individual, to assist those parties to find a negotiated resolution through a typically confidential and without prejudice negotiation process. That mediator may play a role that is purely facilitative. They may just assist the parties to engage in a dialogue and use their tools and skill to help the parties come together. It may in part be evaluative. So the mediator may use his or her expertise, skill, and experience to help parties take a realistic view on their legal positions. Now, mediation is commonly used in many court systems, in particular for commercial disputes, and also, of course, in international arbitration. And I think it's fair to say that those who have used mediation successfully will forever be converts to its use, because it is transformational when you can put parties together and put heads together and use mediation to find a route to settle a dispute or to put yourself down a path to a settlement in a way that helps you to avoid the costs, the expense, the time, and the other risks of formal dispute resolution process. Now, mediation can be quite informal in the context of commercial dispute resolution, but it is unlikely to be so in the context of ISDS. Realistically, the parties to an investor-state dispute will have to engage with the process, invest time in the process. They must agree to the mediation. They must invest time to prepare, very often engaging counsel, perhaps drafting written submissions, perhaps exchanging documents and questions, and then importantly, briefing and taking the time of senior decision makers within their organization, which is true both for the investor and for the state. And so for those who are considering taking that step, now how can we help them to think about whether they should try to mediate and whether they should try to mediate now, when to attempt it, when to make that investment. Now, it's not to say, of course, that mediation cannot be attempted by parties to a dispute at any time, and that it might not generate a settlement at any time or put the parties on a path to a settlement. But experience does suggest that there are some times in a dispute's life and some phases in the dispute's evolution where disputes may be more or less apt for mediation. It may be a more productive use of the process at that time. So what we were attempting to do was help those parties with less experience in these areas to think about the factors that may be obstacles to mediation or may suggest that mediation is not quite optimal, to help them to work through those before they invest the time required to make a genuine and sincere effort of mediation. So we thought about how to put this work product together. We thought about guidance, we thought about a toolkit, we thought about coming up with a set of principles. We decided in the end to try something as simple as we could, which was to see if we could come up with some decision trees to help, again, participants to think about the thought process of whether and when to attempt mediation. We thought that might be the most practical way of approaching things, and that is what we've come up with. And attendees on this call will have received by email PDF copies of the current draft decision trees, and I'll come on to those and endeavour to present those and talk about them in just a few moments. There will be notes attached to the decision trees. We're going to try and keep those minimal. What we haven't tried to do is address the prior question of why should one try to mediate? Now that, of course, is a very valid topic, but we thought that was a prior topic. And once the parties had decided that they knew the benefits of mediation, then really we want to help them to think about when and how, and to do so in a simple way. Now, we're not sharing the notes today. Those will be left for the detailed drafting by the working group. What we wanted to do today was show the drafts as they stand at the moment and see if we can get some feedback and a discussion around the concept and the utility of the idea. No one's suggesting that it is an exhaustive or a perfect work product, but we endeavour to be useful. And what we haven't tried to do is be utterly exhaustive in looking at every question. We've tried to give parties a good, but hopefully fairly simple way to analyse the topic. Now, as a group, we looked first at assisting the state perspective, and we thought that we'd see if we could come up with a work product on that. And then we turn to the investor, and that's the drafts that are currently in circulation. I should say that the presentation of the drafts, the actual layout, is something that we will aim to improve once we have got feedback in a final form, and we hope that we can use some technology to embed the notes within the drafts themselves. I should also say, as I turn to the drafts and as you look at them yourself, the idea is the decision points take you through to a circle, an oval that is red or green. And that is not intended to be a stop or go. It's intended to be, and it's stated to be in the notes, a suggestion that a dispute at that point may be more or less susceptible to mediation, and the mediation may be more or less useful at that point. And again, the aim of the decision trees is not to say you can or cannot mediate a dispute this time, but merely to help, based on the work of the group and the experience of its participants and those other people who've inputted to these drafts, to help those who are coming to the topic, maybe fresh, or certainly to give them some assistance in analysing whether now is a good time to do it. So I'm going to have a go at sharing my screen. So we should hopefully there have on the screen the decision trees. You may find it easy if you have the email, by all means, pull that up and work from that. But I will just put that on screen for those who don't have the email to hand, just while I talk about a few of the things that we worked through. So just starting on the left-hand side of our decision tree, and this is I hope, the state decision tree. So analysing this from the state perspective. So the first theme we developed, the themes run vertically, and then the idea is the decision tree reads ultimately left to right. So the first thing we thought about is whether the treaty itself contains any provisions on mediation, because obviously if they do, then the parties need to think about whether those provisions work, whether they're defective. If they aren't defective, whether it's mandatory, and whether that obligation to mediate has been attempted. And I think here probably we differentiate between mediation as a formal mechanism using a neutral third party and just negotiations during the cooling off period, which of course are a feature of many treaties. So the first question is, are you obliged to try mediation in any event, and have you done so? The next question we looked at is now a good time to mediate? And there are a number of features there, a number of issues the parties may want to consider. And again, looking at this from the state's perspective, where the state is facing an actual or prospective claim. One of the first questions we thought was relevant is, has the claim been formulated and served? Is the cause of action and the remedy sought clear? Because obviously it's going to be harder for both parties to mediate and try and agree a settlement of a nebulous claim. And in particular for a state, which is going to have to act in its sovereign capacity to settle a claim against it if the mediation is going to be successful, or, well, to resolve a claim against it. Of course, it may not settle depending on the outcome of the mediation, but it will probably want to go into those negotiations clear enough about the claim that is being made against it in order to be able to dispose of it. So is the claim clear? We also thought about the issue of jurisdiction, which of course is a tricky and often raised issue within investor-state dispute resolution, particularly in arbitration. And we thought that this could be an obstacle to settlement and to using mediation as a mechanism, because is a state, in this instance, in a position to settle, potentially, a claim against it if it has not yet recognized the jurisdiction of the process and the ability of the party, this investor making the claim, to bring that claim. Now, that is potentially an obstacle. Of course, on the flip side, there may be times when it is convenient for a state to think about settling a claim without prejudice to a position on jurisdiction, which it therefore preserves for the future. So it's, again, not a black and white issue, but we thought one that was relevant to be raised. Another one that we thought was the question of urgent interim relief. And in particular, if an investor is, at the time of asserting a claim, calling for some urgent relief, perhaps to maintain the status quo in the face of actual or prospective state action, is that something that will get in the way of mediation? If there is a need for some urgent decision on interim relief, can the parties in the meantime take the time and step back from the process in order to conduct a mediation? And if there is a need for interim relief, is the state willing to agree to some form of interim relief that will put that issue to one side while mediation is attempted? And again, not a black and white issue, but we thought one that could well be a substantial obstacle to settlement. Moving along to the middle of the decision tree, what other factors might be relevant regarding a readiness to mediate? Has the claim been sufficiently detailed? Again, nebulous claims are tricky to grapple with, but in particular in the context of mediation, does any party need more information or more documents in order to evaluate the merits of a claim? And indeed, does the state have clear advice on the merits of a claim? Again, looking at this from the perspective of state counsel, are they clear on the merits of the claim against the state as they currently perceive it, in order to take a view on potential settlement and to assist decision makers within the state on potential settlement? What about budget? Is budget available for mediation? Again, from a state's perspective, that could well be just a simple but important practical consideration to overcome before committing to a mediation. Are the measures being challenged suitable for mediation? And again, this is not to say that there are any particular claims that aren't capable of being mediated. But I think it's a relevant question for the state to ask itself: is the remedy being sought damages? In which case it may be assumed the state is, in principle at least, able to resolve the claim by paying damages or some amount of damages, if that is the outcome. But if the remedy being sought by the investor is non-monetary and is something which the state feels it cannot bring about, then that, of course, may be an obstacle in trying to negotiate the claim, at least without a realization that the outcome of any negotiation would have to be something other than the claim being brought. Now, what do I mean by that? Well, for example, there could be bigger considerations for the state around issues of security, public health, maybe environment, which means that actually the remedy being sought, the outcome being sought by the investor, is not something the state is able to bring about. And finally, on the state decision tree, we thought about issues of transparency. Now, this again is not a straightforward topic for states or investors, and I think either party can find themselves on either side of the transparency debate in a particular case. But overall, the trend in terms of ISDS is undoubtedly towards more transparency. And what impact does that have on the state's ability to compromise claims? Because practically speaking, mediation tends to be a process that takes place in confidence and without prejudice to the parties' formal positions in a claim. But obviously, if a negotiated settlement, if a mediation is going to take place under the glare of publicity, that could compromise a state's ability to come back from its formal position and to make a settlement which is a compromise of its pure legal position. In a situation where state officials would have to sign off on such a compromise, where there may be public interest litigation or other scrutiny of a settlement, and where in some instances there may be allegations against individuals who have sanctioned or been involved in that settlement. So again, we think practically speaking, that's an issue that state parties will need to be aware of. Now, just briefly turning to the investor decision tree, a lot of this is similar. So the first part of the decision tree, again, we look at the question of the treaty. Is now a good time to mediate? Is more information needed in order to mediate? But we thought there were a few specific points that really from an investor perspective ought to be flagged for consideration. In particular, the box there in the middle of the screen with the number 7 on it is the question of funding, increasingly common in ISDS. So the role of the funder will be important, of course, for a funded investor. Does the funder support the use of mediation? Will they fund participation in the mediation? Will they want to attend and be part of the decision-making at the mediation? And those are all issues that are, again, should not be obstacles to a mediation, but certainly need to be thought about and worked through before time. We also thought there were potential issues from an investor's perspective on enforcement in terms of the remedy being sought. For example, and this is thinking about the creative beneficial use of mediation, is the investor's preferred solution one that an arbitral tribunal could order? Because if it's not, and if therefore the investor's preferred solution is one that will require creativity, because it's not something that a tribunal could order at the end of a arbitration, for example, then that's a strong incentive towards the investor to mediate and to see whether they can get this dream win-win situation where the claim is compromised in a way that suits them even better than an arbitrated decision. Again, there are issues around, we think, whether arbitration awards will be paid, if they're given, whether there'd be enforcement difficulties in pursuing an arbitration award, because again, if there would be, then that could well be a factor towards looking at a settlement, a negotiated settlement and a voluntary payment rather than seeking to enforce an award in due course. We had to think about the Singapore Convention. I think this is an interesting topic and maybe one for further debate and questions. Does the Singapore Convention apply? Is the state in question a signatory? And then, perhaps more importantly, does the convention cover the dispute in question? Is it a commercial dispute within the terms of Article 1 of the Singapore Convention on the enforcement of settlements derived from mediation? And I think it's hard to decide that in the abstract because you have to look at the dispute and claim when it arises. But again, it's a point that we've flagged on here and we think it is relevant for states to consider. I think that's probably enough for me to talk about now. I'm going to turn away from the drafts. And I'm going to hand back to our moderators and to my fellow panelists. And I should be very interested to hear their comments and their thoughts on the drafts and this attempted work product.
Thank you very much, Nick, for that very thorough introduction. I thought it was very helpful to understand where the working group is coming from, what they're trying to achieve. The way we have planned to go about it now is to basically have our webinar divided into 2 parts. And in the first part, we will not delve straight into the decision tree, but we will ask our participants, now also joined by Frauke, to talk a bit more generally about their experiences with mediation. And we want to solicit different perspectives on mediation. And then in the second part, we'll particularly invite Natalie and Frauke once more and ask them about their views on the decision tree. We will ask Santiago a little bit less because he's biased. He has helped create those decision trees. So of course he will say they're great. But let's start with the first round, basically, the first section of our webinar. And I would like to invite Santiago to go first here. He has experiences in specifically Latin America, often on the investor side, dealing with states having tried to achieve settlements. And we would, of course, be curious to hear a little bit from you about your experiences, whether you have done mediations, whether you have done something else, and what you think about mediation, in particular in investor-state disputes.
Thank you, Lars. Thank you very much for the invitation, and it's a pleasure to be here. And today I want to focus in what is my experience, where the main challenge that the investors, in my experience, have faced for the development of amicable dispute resolution mechanisms in general and mediation in particular, which is not very common in Latin America yet, is the absence in most host states of a national legal framework providing for a clear authorization for officials to attempt to resolve disputes in this way. This is, in our experience, applicable for both regular negotiations and, in particular, mediation, which is the topic that brings us today. That is the absence of an authorized interlocutor on the side of the state, which is usually not the counterparty in their concession or contract, that is duly authorized to engage in a mediation proceeding with the power and, most important, willingness, because of what I'm going to mention now, to enter into a settlement. Despite when the chances in the dispute are unfavorable to the state very clearly, and when the investor is clearly willing to reach a settlement. And I'm going to mention some experiences in some countries that show empirically that the results obtained by the states through settlement are much more beneficial when they had awards and when they waited for the results to the issuance of an award by a tribunal. And this is of special interest in Latin America, which is the market where I mainly work, which is magnified by the fact that public officials involved in a settlement could be, and experience shows that they usually are, subject to threats of personal liability, either economic or criminal liability or both, and sometimes even subject to allegations of corruption. This is a particular problem when drastic changes in government occur, which is also, unfortunately, a common feature in Latin America, as we are experiencing right now, for example, when a government of the opposite political party comes to power and wants to redo or revisit what has already been done by prior governments. And usually these kind of settlements on investment disputes are sensitive, involve some of the major projects in the country. So the threat of personal liability and the lack of authorization or willingness by the public officials to enter into a settlement, I believe in my experience is the main limitation in my experience. This concern is in part included in the notes to the state decision tree in relation to step 10 related to the publicity of the investor's claim. We are going to see later probably discussions between the confidentiality and the transparency contrast that mediation involves. The cultural aspect is very different. In some jurisdictions, such as China, mediation can be an essential process of dispute resolution rather than a voluntary alternative, and ISDS mediation can take advantage of that cultural difference. But this is not the case in Latin America. It is easier, in my experience, for a public official to avoid entering into serious amicable dispute resolution mechanisms until the arbitration is commenced, to be able to show the government or the public that if the arbitration is settled and stopped as a consequence of a mediation, they have something tangible to show. In fact, trigger letters and even requests for arbitrations are used in practice by investors as leverage to try to force states to the negotiation or mediation table, and it usually works. This problem has also been signaled, not only by me, obviously, as the main obstacle to the use of mediation in ISDS, among others by, for example, the former president of the ICJ, of the International Court of Justice, Stephen Schwabel, almost 15 years ago. He said that there is an entrenched tendency among both government and corporate bureaucracies to shift the responsibility to a third party, like the tribunal, which determines the outcome in its award, while in mediation, the parties ultimately need to assume responsibility for the terms of the settlement. And this is the main problem for public officials, at least in the region where I work, that is Latin America. We have been told in person that they need for the arbitration to be commenced in order to be able to enter into serious discussions. And this obstacle is also shown in surveys. For example, in 2018, a survey on obstacles to the settlement of ISDS dispute reached the same conclusion, complemented with the finding that, in the view of 70% of the participants, states were more reluctant to settle than private investors. Mentioning some countries in Latin America that can serve as an example, I can mention my and our experience in Bolivia. Out of the 13 investment arbitrations commenced against Bolivia, 9 were settled, which shows that there was an intention or a tendency by the government of waiting until the arbitration is commenced to be able to enter into serious discussions. 2 were decided in favor of the investor, and 2 are still pending. But what is interesting is the percentage of the amounts recovered by the investors. In the settled cases, 9 out of the 13 cases, the investors recovered between 10 and 34% of the claimed amount. Only in one case, about 50. While in the 2 cases that they left for the tribunal to decide, the investors recovered 75 to 90% of the amounts claimed. And in both cases, the state obtained unfavorable awards. This shows that Bolivia has obtained much more favorable results through settlement than arbitration so far. There were also several investment disputes settled even before reaching arbitration. In our experience, we were involved in many of them, especially in the oil and gas industries. But the risk of personal liability in practice prevents states like, for example, Bolivia, for entering into real amicable dispute resolution mechanisms in an early stage, even when they have high chances of losing a case, like experience has shown, and or when the investor is really willing to settle. Another example of this reluctance, in my experience, is Ecuador, which in general doesn't even enter into real negotiations until the award is rendered. They fight until the last available resource, even when their chances are slim. In fact, they have received unfavorable awards in almost all of the cases they let to be commenced without unfinished and decided by a tribunal. Only after obtaining an unfavorable award, they try to negotiate a decrease in the amount of the award on the interests. But as a matter of personal liability, public officials usually don't enter into serious negotiations. And what is the reason for this? Well, there is this this public body called in Spanish Contraloría. That is like a sword of Damocles that hangs over the heads of public officials. Contraloría in English could be translated to state controller. They are public bodies, supposedly independent from the political power in government, in charge of reviewing the legality of the contracts and agreements entered by public officials, even several years after their execution, even after the public officials left office, which can assign responsibility to the public officials involved and prosecute economic or criminal liability in court. And this has been our experience, for example, in Colombia and Ecuador and Bolivia, among others, that where the contracts and agreements, settlements or others, were reviewed, especially after a change in government, several years ago. So it is easy, as the former president of the ICJ mentioned, to shift the responsibility to a third party like the tribunal to decide the dispute and avoid any responsibility. To finish this first intervention, and not to bore you anymore with Latin America, what has been one of the possible solutions for this problem, at least in my region? I am aware that other regions like Asia are different, and we will hear Natalie's experience probably in a few minutes. There has been greater awareness of this obstacle, and they are trying to, there is a certain consensus among commentators on the need of having a centralized authority model. For example, in 2018, the Energy Charter Secretariat released a model instrument on management of investment disputes, and there they devote a great attention to the functions of a centralized responsible body to serve as the central focal point throughout the whole process, with exclusive authority for the resolution of disputes and responding to the highest executive power or to the parliament. therefore obtaining certain political or legal consensus or coverage for the public officials involved. This is also mentioned in ICSID's paper on the overview of investment treaty clauses on mediation, which also mentions that a growing number of treaties specify the agency to which requests for amicable dispute resolutions are to be directed. And I can mention Latin America, the VITs entered in 2018 between Australia and Peru, and Argentina and Japan. So this problem is started to being addressed by the relevant states, acknowledging that is one of the main problems for the development of mediation. And with that, almost on time, I will leave the floor to my co-panelists.
Thank you, Santiago, for shedding light on this critical obstacle of personal liability when state representatives sign a settlement agreement. Indeed, in certain jurisdictions, issues of ostensible authority intensify when a state official exercises authority under the seal of a state, and it's helpful to know the solution to this problem. Before we move on, I request all attendees to please post their questions in the Q&A function, as we will be unable to call on people to put forth their questions while they raise their hands. So let us now move on to the...
There is one question, Kashama. I don't know when are we going to answer them, but there is already a hand there in the...
Yes.
The attendees.
Indeed. I think we will take all questions in the 15-minute Q&A session that we have towards the end of the webinar.
Sorry.
No worries. So let us now move to the party which is at the receiving end of a claim, the state and its perspective on use of mediation when an investor initiates a claim. I will pose these questions to Natalie. Natalie, we understand that you will be sharing your views today in your personal capacity. And you have been active in mediations and have also participated in the UNCITRAL Working Group 3 sessions on ISDS reforms on behalf of the government of Singapore. Could you share your experience of use of mediation by a state, and particularly Asian states, in an investor-state dispute? And also, maybe you could throw some light on what is the approach of the UNCITRAL Working Group 3 towards mediation of investor-state disputes?
Thank you very much, Kshama, and thank you also to the organizers for inviting me to be a part of today's session and to share the state's perspective. I think just to go directly into the questions that you have posed, and then I'll approach my time in the way that you've outlined. The use of mediation. States, I would say, appreciate the value and the utility of mediation as a form of dispute resolution, as a form of alternative dispute resolution, depending on where you stand on that term. There's a recognition that we're talking about public policy issues that are being challenged when an investor brings a claim, impinges on the right of a state to regulate on public stakeholder interests, and there's usually an intended long-term relationship between the investor and the state. The money that's at stake is also very, very high. So against this kind of backdrop, it's not lost, I would say, on states generally, that mediation offers a lot of pros in terms of the flexibility to design your own outcome to the dispute. And this form of creative solutioning, I think, is particularly appreciated in the investor-state context, because you're able to go into solutions that may extend beyond what triggered the initial dispute in the first place, beyond monetary compensation. And by retaining that control over the outcome, it means that to the extent that there may have been regulatory chill that may have arisen from an arbitral tribunal's decision, you won't be getting that in the case of a mediation, because there's no imposition of an outcome on a state. And the traditional benefits of mediation that we see in the commercial context, the preservation of the relationship and the flexibility of the process, I think to a certain extent also enhanced in the investor-state dispute settlement context with regards to the flexibility of process, because with investor-state mediations, very often in view of the public interest, the involvement of local communities and having them being able to have a voice at the table, this is might be a bit more difficult to accommodate in other forms of dispute resolution mechanisms if they've not been set up to achieve it. But with mediation, because of the flexibility, this is something that is possible as well. Now, that being said, I'm very conscious of what Santiago has mentioned, that there are obstacles to states that are mediating. And in fact, in the UNCITRAL context, and this leads me into the second question that you posed, in the context of the work of UNCITRAL Working Group 3, there's been recognition that mediation is in many regards underutilized. Even though the benefits are widely acknowledged, there still seems to be underutilization of mediation as a form of dispute resolution. And there have been a couple of studies that speak to this. I mean, Santiago's mentioned one, and in the Singapore/Asian region context, there have also been a couple of studies and reports that have been generated over the years. The 2016 report of the Center for International Law, I think, drew out the fact that that we've already heard this morning or this evening or today, that states prefer to defer responsibility for decision making to third-party adjudicators so that they can get out of any allegations of corruption or public criticism that may come along the way. And then in the 2020 SIDRA, Singapore International Dispute Resolution Academy Dispute Resolution Survey, they added an additional element to why there might be issues with investor-state mediation, but coming at it more from the investor perspective, I suppose, because of the question of enforceability. But similar observations, as I mentioned, have been made at UNCITRAL Working Group 3, that there are accountability issues, perhaps, in the system that prevent states from jumping at mediation, even though it may have many benefits. And in view of this, the working group actually has been trying to consider how mediation may be more widely promoted and more widely used. There's been some work that's already been delivered in this front in respect of the Convention on Mediation that came about a couple of years ago. But now, in the context of investor-state dispute settlement reform, UNCITRAL is working on model clauses and draft guidelines to foster familiarity with and the use of mediation. And these model clauses, for example, could be reflected in an eventual multilateral instrument, should one be developed. It could serve as a basis as treaty text negotiations. It could also be incorporated into the procedures of a multilateral investment court to the extent that one may be established. And I think this work is being done against the backdrop of the existing treaty trends, where we've seen over the years in the older investment treaties, mediation is either not explicitly referred to or referenced without elaboration, but we're seeing a trend now towards more detail in the newer investment treaties, frameworks and annexes on mediation, some treaties mandating mediation as well. And we've got some countries in the region that are of that view, having mediation as a necessary prerequisite to arbitration. And but I think before we are able to see this more commonplace express reference in investment treaties, there needs to be a buildup of familiarity and comfort with mediation. And perhaps how we can put it is these model clauses and draft guidelines, similarly minded projects like the IPBA decision tree are means by which we can get investors and states to be nudged to think in this direction about what they need to do in order to use mediation effectively. What are the appropriate government structures that need to be put in place? What are the internal processes that can be introduced to promote accountability? And the various solutions would depend on the types of countries we're talking about, their cultures, their domestic structures, to a certain extent, their international contexts. And also, very importantly, and perhaps Frauke, I know Frauke has spoken with it before, and I don't know if she'll touch on it today, but there are certain gaps in capacity building that could certainly be usefully filled. And I see all these model clauses, draft guidelines, and decision trees as very useful tools in that light, so that states and investors moving forward can start actively considering mediation whenever they're faced with a dispute or a potential dispute. So I think that brings me more or less to my time, and I hope it answers the questions, and looking forward to hearing from my fellow panelists. Thank you.
Thank you very much, Natalie. That was really interesting. And I was, of course, very glad to hear that when you talked about model clauses, other guidelines, you also started mentioning the decision tree. So we hope we're on a good way. You also mentioned that mediation might be underutilized and there's more capacity building necessary. And you mentioned Frauke's name in that respect, who now is our next speaker and will address the issue a little bit from her institutional perspective. And in that perspective, she's very involved, I think, in capacity building as well. But Frauke, we would like to hear from you a little bit. What are your views of challenges, obstacles when it comes to mediation? And of course, I'm sure you have to report somewhat of what ICSID has been doing in that realm.
Thank you so much, Lars, for the invitation to speak here with my fellow panelists, and who knows me knows that I can get excited about mediation, and hearing all the different views already from Santiago, touching upon sort of the state issue, the organizational aspect, the model instrument, Natalie looking at the working group 3 and sort of the view of mediation, and its underutilization, and the goal of it to promote it further is just a lovely way to start the day. So thank you for that. And what I thought I would do in the next couple of minutes is to look at some basics that might be helpful for us to set out, certainly for me, and then we can pick this up later on in the discussion about the decision tree. And I hope, I don't know what you see, but I hope you see a slide with a definition of mediation. Is that right? So I entirely agree with what my fellow panelists have said, and that is capacity building, familiarity, where buzzwords here. What is mediation? There is still a big misunderstanding, especially in the arbitration community, of what is actually mediation. And that's why I wanted to start out with a definition that really brings out mediation is negotiation between the parties assisted by a third person, with the parties obviously in the control of the outcome, whether to settle and how that should look like. So it's not an informal arbitration in that sense. It is much closer to negotiation, which I want to show on the next slide. Just to get the theoretical concepts right, you have here the graph on the impact on the parties' control over the outcome. Is it the parties decide, or is it a neutral like a tribunal or a judge? And what is the process control of the parties, and max or minimum? Informal, formal, consensual, adjudicative. So you have the different aspects here. And you see, obviously, litigation, less control by the parties over outcome and process. And on the other end of the spectrum, you have the negotiation, where the parties run the entire show from the process to the outcome. And mediation is not close to arbitration. In fact, it is very close to negotiation, with this third party neutral, the mediator, being there to facilitate the parties' negotiation. Important, especially for arbitration practitioners, I find, is to differentiate this from early neutral evaluation. The mediator is not a person who comes in and says, well, if you look at the treaty, this is what the outcome be if I were to decide it, and now you parties negotiate. That is not the concept of mediation based on the definition that we looked at. There, it's about the parties looking at the dispute to find a resolution. So looking at ICSID as an example, Lars mentioned the institutional aspect. So we came to propose the mediation rules to our member states because of the trends in BITs, because of the work the Energy Charter Treaty and Energy Charter Conference had done. Over 50 member states of ICSID supported the work on mediation. And of course, the statistics, that is what ultimately triggered my interest in mediation in 2005 already, when I worked on institutional aspects at ICSID, and 30 to 40% of all arbitrations are settled. Then you wonder, and Santiago had mentioned the Bolivia example, then I wondered, is arbitration the right process if that is the outcome in so many cases? And so If we look at the scope of the mediation at ICSID, we are authorized to administer any mediation that relates to an investment involving a state or an REIO, Regional Economic Integration Organization. So what you see here is there is no link to ICSID membership, there is no link to nationality. These aspects that are traditionally being discussed and argued on jurisdiction, on nationality, and membership or designation, for example, under Article 25, you do not see in the mediation. The consent, conceptual difference, consent in mediation is not only at the outset, but it's throughout the process. So we call that ongoing consent. You can unilaterally withdraw from a mediation at any point in time. That is the mirror to the jurisdiction aspect that you have in arbitration. If you don't agree with the jurisdiction of a tribunal, you want to get out and you argue that. Here, you don't actually need to argue it. You can leave at any point in time. So how does the ICSID mediation process work? We have here on the slide a brief process overview. The institution is different from what you may know in other ICSID frameworks, arbitration or conciliation. Here you can come with a request that already contains an agreement, or you can come with a request that contains an offer that we then transmit to the other party, helping establish this consent to mediate. And if the other party doesn't react or respond, no further action will be taken. If there is a consent built through that process, we will continue the review of the request and the registration process. Subsequently, you have one or two mediators, so the difference in process from arbitration or conciliation where you have three. The parties file brief initial statements right after the mediator has been appointed, and then you have a first session where the parties and the mediator develop a protocol. What's important at the first session, and Santiago spoke to that already, is that at the first session, the parties need to identify a person or entity who is authorized to negotiate and to settle. And so those are two different things. The people at the table need to have negotiation authority, and the ultimate settlement conclusion may be, as we've heard, lie in a different entity, like Santiago mentioned Peru, depending on the state organization. So, but that needs to be clear at the outset, so you have a good basis for the subsequent negotiation. The mediation will then be conducted on the basis of this protocol, and you have different termination option, obviously a settlement agreement, or the parties agree to terminate the mediation, or the mediators may decide or determine that there is no likelihood of resolution. Now, what happens in a mediation, and I think this is important, what we will see in a minute for our discussion. You have this initial phase. This is based on the ICSID model, where you put everything in place. You have the registration of the request, you have the mediator appointed, you have initial written statements, you have the protocol. So you create the basis for the mediation to take on. Then you have, in a state setting, a pretty formalized version of opening statements each side. And then you have an exploratory phase. Here, what the mediator will engage with the parties to identify the foundation. What is it that moves the parties? What are their motivations? What are their interests? What are their needs? What are their fears? What are their economic pressures? To get a holistic point of view of the dispute. And I think that is an important aspect for us to address in the discussion about mediation. And when you talk to some general counsel and some mediation participants, this is what they find most helpful: to not jump directly in positional bargaining and negotiation, but to take a step back and to put everything out. And once you have this exploration aspect, you create your ingredients for settlement. Then the negotiation, you generate options, you look at packages, what do you put together? And then you have a final phase where, in the event you get a package, a settlement package, you look at the detailed terms, you look at approval processes. And in the investor state context, this takes more time than in a commercial setting. Who all needs to sign up, which ministry, which budget authority, which other entity is involved in signing off on this deal. It may be just part of the dispute is settled, or the parties may conclude, you know what, we tried, but this is not the process or outcome that I would sign off, and then there is no settlement. That doesn't mean that the mediation may fail. The parties frequently report that even going through a mediation that doesn't lead to a resolution is helpful to learn about your strengths and weaknesses of the case, what's really important to you, and so that you can focus other dispute settlement processes on those goals for you. So one of the things that I also thought about is, what is mediation? And in the early days, mediation was often considered as an option during the cooling off period. And I thought that that may not be the right time. And Santiago alluded to that already. Requests for arbitrations can be leveraged to put pressure, states tell us, depending on the formulation of the request for arbitration, they are more likely or less likely to engage in discussions. The World Bank has done research on this, concluding that at the time of the request for arbitration, shortly thereafter, that is when most cases actually settle. And here we get to the organizational aspect. This is when many states actually learn, oh, there's a dispute. There's something that we need to address. That is, you know, the issue of attribution in legal concept is beautiful from a legal perspective. When you have a dispute with a subsidiary or a local water authority, until that reaches the minister that we have a problem here, things and years pass by. So if we accept the fact that mediation is actually assisted negotiation, you see it on the bottom there, mediation is actually available whenever negotiation is suitable. And so you can have mediation not only alongside an arbitration or during the cooling off period or after an award, what Santiago mentioned, but you can have it all along. You can actually even have mediation in the conclusion of a concession agreement. And in our trainings that we have done, parties had considered whether they wanted mediation in the context of the negotiation of the FTAs. And I can see that that may not be a bad idea if you sign up on the premise that mediation is assisted in negotiation. If you look at operations, investors want actually to have the dispute settled during the operational phase. So you don't get to the sort of removal aspect of the arbitration route when you get to a notice of dispute. And that, I have a slide, but we don't really need to look at that here right now. On the treaty provisions, we have done that research. Natalie has already presented sort of the trends in the treaties, but just to mention, we have the investment treaties mediation provisions and a background paper, and we certainly do a lot of training for states and mediators and investors as well to support the familiarity and the awareness and what mediation actually is. So that's my first time.
Thank you, Frauke, for your very helpful presentation on ICSID's approach. It is particularly useful to see that states have broad access to mediation facilities with the ICSID, irrespective of their nationality. And again, ongoing consent is again an ever available useful remedy. And now let us move on to our next section on the decision trees. Before that, let me thank Nick, Santiago, Natalie, and Frauke for sharing your vast knowledge and experience in this area with us. And while we hear from our speakers, we urge all attendees to post their comments, questions, and feedback on the decision trees in the Q&A box. So let me again pose this question to Natalie. Natalie, what was your first reaction to the investor decision tree? Do you think something was amiss, something can be improved? Can you share your feedback?
Certainly. So maybe just one point on the investor decision tree, and that's specific to it. And then depending on how you want to structure the discussion, I can go into the comments of the state decision tree that I also shared with the investor decision tree. So in your hands on that. But with regards to the investor decision tree, one thing that I noticed was what does not appear is the issue of transparency, even though that features on the side of the state decision tree. And I guess I frame my comment in the form of a question as to why this might be the case. I mean, I come at it from the state's perspective, but even then I would have imagined that transparency would also be a consideration for investors as well. There have been initiatives in many mediations to have specific media or public disclosure protocols, and these are not always initiated, at least in my understanding, by the states that are involved in the mediation, but sometimes by the investors as well. So understanding that there are different types of transparency and confidentiality, either in terms of the phasing, the chronology, in terms of whether it's delayed or immediate, in terms of whether you'd make known of the entire process, the mere fact of a mediation, not necessarily the mediation process being entirely open, and then in terms of the the mediated settlement agreement, whether or not that is made available in total or simply the broad brushstrokes are made available. So understanding those kinds of considerations and factors, a question, I suppose, to those who put so much thought into this, to illustrate for us why transparency doesn't feature in the investor decision tree. Thank you.
Thank you. So I think we'll maybe pass this on to Nick or to Santiago. So maybe Nick, do you want to go first on that particular issue?
Sure, absolutely. And thank you, Natalie. Good to get some feedback. I mean, I think so. Just a couple of points, really. First is that I think both decision trees are relevant to both parties in the sense of, and we include this in the notes, both parties can benefit from seeing what we think might be the obstacles to considering mediation and a mediated settlement for the other side. And when it comes to transparency, we thought this was, it's not that it couldn't be a factor for the investor, but we thought it was really not so much an obstacle for the investor, but in practice, and for the reasons that Santiago has already mentioned, we think it's a big obstacle for state parties, because we think the ability to settle cases and to compromise from a formal legal position is particularly difficult on the state side, and we think that the trend towards transparency and transparency in a particular case may exacerbate this. Now, of course, there are reasons why transparency is also a very good thing, but we think in the context of assisting the parties to compromise and reach a negotiated settlement, transparency is a particular factor for state parties because they are not inherently so able, and individuals within an organization at the state level are not inherently so able to compromise and reach a balanced outcome. Now, we think that conversely, commercial parties are by their nature better, and it's more part of their day-to-day reality that they negotiate, they compromise, they balance factors to come to an outcome. So we thought that for an investor, the effect of transparency in any part of a negotiation process is far less chilling. Obviously, investors, senior management at a company, for example, would have to report to their stakeholders, would be accountable to perhaps their more senior management, certainly to their shareholders or other stakeholders. They'd have to be able to explain what was happening, but we don't feel they're under quite the same difficult position in terms of scrutiny and explaining how they compromised in terms of public resources as a state party. So we thought, of course, I think it can be relevant to both sides, but we thought it was, in terms of the thought process, the necessary obstacles to work through, particularly relevant on the state side.
I fully agree, if I may, Lars. Part of the decision-making and the considerations ongoing to mediation, it is more relevant to the state. I just want to note here that there is an interesting clash between a tendency toward transparency that has been promoted in investment arbitration and has been one of the main criticisms and the alleged backlash towards investment arbitration that had led to the increase of mediation as part of those criticisms, implies in a certain way, or is benefited by the confidentiality of a mediation process where the parties can discuss their dispute more candidly. So I just want to note this clash between the trends of transparency in investment arbitration and one of its criticisms due to the alleged lack of transparency that led to the development of mediation, that as a process can benefit from confidentiality. So it's sort of the chicken and the egg, what goes first and what has to be prioritized. But I agree with Nick that in the process, this transparency issue is less of a problem for the investor than a consideration for the state. I also want to mention one, if I may, Lars, sorry to abuse of the time, one factor that Natalie mentioned, I believe is very important also for the appropriateness of mediation for a specific dispute, that is the existence of an ongoing relationship with the state. And this also goes to the issue of transparency or not, what information is disclosed or not during an ongoing relationship. We have had investors
I don't hear him anymore.
waiting for 7 years to come, never came because they had ongoing. You don't hear me anymore?
No, yeah, that's good.
Sorry. Regarding the maintaining of the relationship, we have had when the treaties don't provide for a statute of limitations, we have had clients waiting for several years, 6, 7, 8 years to commence the arbitration, waiting for an amicable dispute resolution that never came due to the existence of an ongoing investment or prospective investment in the state. While that tendency to go straight to arbitration is much more higher, the probability when there is no more relationship, as Natalie mentioned.
Okay, I see that Frauke has unmuted herself, so I think there's an additional comment. So we'll invite Frauke to comment.
So I structured sort of my thoughts on the decision tree, but we were talking about transparency, so why don't we start with that? I think in my vocabulary, I differentiate between transparency, which is used in investment arbitration, and information disclosure for mediation. It's a slightly different way, but it's also a slightly different context. If we start on the premise, or maybe I could say first, in the negotiations of the exit mediation rules, which I should mention will enter into force on July 1, have been adopted in March, the questioning of mediation being confidential was not a controversial issue. I should say that in the exit rules, mediation is not, the confidentiality is not absolute. It is subject to party agreement for disclosure. It is subject to any applicable law that the parties may need to adhere to, or if, excuse me, party agreement, disclosure, or if the information or document is otherwise available, right? Mediation is not allowing you to cloak anything you can get otherwise. So the point is, if we look at the state's obligation, if you look at it conceptually, in my view, there is obligations to keep things confidential, and those also apply to states. That is domestic legislation that requires the state to keep things confidential. Then there is limits to that confidentiality also by the rule of law. And then you have affirmative disclosure obligations. And the sources of these disclosure obligations can be domestic legislation, can be treaties, which are implemented, or party agreement. So I think if we put it in that sort of conceptual context, we get away from a broader discussion about confidentiality. That is a bit nebulous, perhaps, and it makes clear that if you have a mediation with the state, you will always have one version or another publicity or public disclosure. The question is, what is the origin? And you need to be in the mediation. The mediator and the parties need to work on this very clearly, of at what point in time will things be made public? Look at concession agreements. Negotiation on concessions agreements in many legislations that I looked at, domestic jurisdictions, they have, as Natalie pointed out, either the concession is out or certain pieces is out. The question of timing, when is it publicized? Is it during the negotiation? Is it when it's concluded? And the same thing applies to negotiated settlements. Or whether you have a dispute in between, the concept is the same. So I think you will always have publicity. If you look at the settlements that come out of investment disputes that were at one point or another subject to arbitration, you can Google, I've done a research, you can Google and find out what the outcome was with the detailed terms in about 70% of those negotiated settlements. So I think that is just a fact. So from the decision tree, I would hesitate to come to the conclusion that just because the dispute, the claim, or other aspects are public, that makes mediation unsuitable. What I would say is, what it means is that you have to build in process aspects and be aware of that this is part of the investor-state mediation, which is different from commercial mediation. But just the fact that you have the publicity is actually an advantage. You can have pieces of the public constituents, landowners involved in the process. And as an example of what is existing where you see this is public rulemaking. Public rulemaking, or where you have the general public or constituents involved in negotiating a legal framework. So if you want a more tangible dispute focused example, then you take the tax mediation. Tax mediation, I've looked into that. You have at least 20 jurisdictions around the world where you can mediate the ultimate sovereign power of collecting tax. How that looks is different. How public that is different. And that's very interesting where transparency is on that. But Australia is an example. I think the famous one is the Crocodile Dundee actor was involved in a big tax dispute and everything was in the papers. But that didn't impact the mediation as such. What it impacts is negotiation points, right? Is that your negotiation power if everything is in the public, but the process itself is still an option.
Okay, so I think we'll take this away. The working group will take that comment away and reconsider that point. What I would suggest now in terms of process, since we're already running a bit short on time, we would nevertheless like to hear specifically from Natalie and Frauke some of the other points. I don't think we will have the time to moot them like we did this now on the confidentiality, but we'll be very keen to hear from you what other points you kind of say, well, this might need to be rethought a little bit more. And maybe we'll go back to Natalie, and she mentioned she had some comments on the state decision tree.
Thank you very much, Lars. Just to say, I agree with Frauke that perhaps we do not need to be so definitive on the issue of transparency and confidentiality or information disclosure in the context of the state decision tree, and also using the state decision tree as a launch pad. A few of the other points that I mentioned, so during our informal chats in the run-up to this session, the desire to maintain a relationship, to what extent is that important to the parties that may be involved? And this would be important for investors, but also for states, because oftentimes in an investor-state relationship, we do see that it could even be akin to a symbiotic relationship between the two. So something for states to potentially consider as well. The other aspects are whether or not there could be multiple issues in dispute between the parties, and some of these could be mediated and some of these maybe could not be mediated, or some are ripe for mediation and some are not ripe for mediation. I think it's useful to have that clear in in one's head. And the other, just to kind of round off with a good 3 points, is there may be multiple parties involved in the dispute and sometimes these multiple parties may have differing interests. So on the one hand, we could be talking about we could come at this question from the angle of non-disputing parties, but on the other hand, you could also come at it from the perspective of multiple claimant investors. And this it could be a relevant factor to take into account when assessing whether or not mediation is suitable. I think there are certain other sources that seek to enumerate relevant factors for consideration, and Answer Trials got a little bit of a checklist in one of their recent documents on the draft guidelines. I think the Energy Charter Secretariat has also come up with a guide on investment mediation that offers a bit of a nod to some of these factors. It's useful to see it contextualized in the form of a decision tree, because we see how the process may move and how the phases may interact, and how we may use the tree to move from one question to another, and also to track our own reassessment of the factors. But just to highlight some of the factors that are across these different tools. Thank you.
I can pick up, Lars. In the interest of time, I jump right in. So first of all, I jumped into the transparency, but what I wanted to make sure is that I really love the idea of the working group and all the work that you put into it. Clever people thinking about mediation and having discussions as we do now, that will all move us forward. And so thank you very much for all the work that you did. Starting out on a couple of points that I would like to mention is, I thought the notes were really helpful, especially at the beginning, how you have laid out that the idea is actually to make this applicable to many kinds of instruments. And that would be my first point. I would, it might be helpful to not narrow it to the treaty. Because even though we have treaties and we are all happy that we see treaty trends on mediation, in my view, the near future will be party agreement on mediation. It will not, the treaties will not play the most important role in the next 2 to 5 years. But as they were with the BITs, once you have them in the treaties, those dispute settlement provision, they will play a role. But I think it might be helpful to broaden it at the beginning. As you will not be surprised if you remember that you saw my chronology of the dispute and dispute settlement option, and that mediation is available throughout. I question the assumption or the premise that the cause of action and the claim need to be clear and served. I'm not sure that's the truth for that this is in practice the case, because you have a dispute. We need to go back to the dispute, in my view, rather than the claim, sort of to look at it holistically on what is happening. Then the abstract legal tool to look at it, what can I get on the basis of what fact? And that is where I think what you also see there, and I'm very happy about it, and I am supporting it wherever I can, there is a difference in treaty drafting between a notice of intent to arbitrate, a notice of claim, and a notice of dispute. And in my view, and there are different, these are policy tools that are specifically chosen. And in my view, what you want is a notice of dispute. Because once you have the notice of dispute, you start to realize, and we put that in the treaty analysis, what are things that the state needs to know to make a conscious choice for the process to choose. That's what we need to get back to. I have a dispute, and now I have different tools, and what is the best for this? And so there I would caution on that. Jurisdiction does not need to be accepted, in my view. I think maybe what you mean here, this is all from the states tree, is that the parties agree that the dispute falls within the scope of the treaty. That's a different issue than jurisdiction, because the tribunal's jurisdiction may be linked to different preconditions. It may be limited to certain disputes under a treaty if we stay with that. But as I tried to set out in the mediation, the mediator does not have jurisdiction. The mediator has a mandate and a scope of application maybe, but he's not there, he or she is not there to decide anything. So that I would caution on the wording on that. And then in the decision tree, where I thought in number 8, you have the other measures challenge suitable for mediation, and the points that are underneath go to the remedy sought. And that's two different things. The measures challenged, I would reframe that as well. It's about the dispute. It's about the dispute between the investor and the state, and the measures relate to the dispute. I would broaden it just conceptually, and then differentiate between the actions taken by the state that led to the dispute, if we stay with that. That's the past. And what you have in these boxes is, what is it that you want as an outcome? And those are two different things that, in my view, are not necessarily linked. So the question whether you can negotiate when the dispute originates about legislative measures is answered in practice. If you look at discontinuance of exit arbitrations, you have a large proportion where legislative measures were at issue and the parties settle. So that's a question on the measures. And then the issue is the remedy sought. And I would be careful to put those points into a decision tree, the goal of which is to look at whether mediation is suitable. So I haven't started it, because what the settlement, the eventual settlement might be, may not be so clear at the beginning. It depends on the package deal that you negotiate. And so those 2 points I would set apart. And then there is an aspect about enforceability. And I think maybe the way to think about it is compliance. If you have concern about compliance. And then the next question to me would be, how would you address concerns about compliance? And you can only know concerns about compliance when you know how the settlement looks. What is the agreement? And you may not know that before you started negotiating. And from statistics, again, if we look at exit cases that discontinued, that have a settlement agreement that is known, out of what I think the number is 212, when I looked at it, only 5 came back. And you would hope that they have good settlement provision, dispute settlement provisions in the settlement agreements that may allow you to come back to arbitration if there's a dispute. So from the statistics, it seems to show that once you have a settlement with the state, and it may be difficult to get there, it usually holds. And the last thing I wanted to share, and I forgot that earlier, is Nathalie mentioned that the UNCITRAL and the Energy Charter, and we put it also in the investment mediation background paper. What are ways to think about to determine suitability? This is not a decision tree, but this is sort of different aspects you can think of. And the number 1 point, in my view, is there willingness to negotiate? If you do not want to negotiate, you don't even need to think about mediation, you go straight to arbitration. And there are situations where that is the case. And then we have the relationship aspects. Is there deep distrust or hostility? It goes to the idea of the continuation of the relationship and negotiation. Do you want a rapid resolution, more rapid than what you could achieve through an arbitration, for example, the control of the outcome? Do you want tailored solutions that the treaty doesn't allow you, specific performance of some form, perhaps? And then the big aspect, are there multiple conflicts or issues? And sort of what I would call a comprehensive analysis of the dispute is necessary in order to identify which of these aspects do I want to negotiate and which do I not. And then the differing interests. Generally, you have in an investment disputes different state entities involved, and they have different interests. And so may have the subsidiary and the parent company. This is not only on the state side. So this is just different aspects that I wanted to offer, and I really hope that this discussion continues beyond this webinar. I find it fascinating what you are doing, and I really thank you for the work that went into that trip.
Thank you very much. That's a lot of takeaway. So if you saw basically my head down all the time, I was taking notes. And I think our other members of the work group were as well. That's been very helpful. Unfortunately, I have to say, we have come to the end of our time for today. Maybe a quick 1-minute word from Nick, and then maybe Shama will conclude and wrap up.
Thank you, and thank you to Natalie and to Frauke for all those thoughts, which, as Lars has said, we will take away and think about further. I think just an initial reaction, Frauke in particular, I think, again, just to emphasize the point about this decision tree, it's certainly not saying that certain of these criteria are barriers, say that you cannot mediate. What we're trying to do here is take as a starting premise that mediation is a good thing, and that parties and states should be encouraged to think about it. And then when they do, to give them a route to think about how best to use it, what sort of issues they need to have in mind to overcome, not they can't overcome them, and what might make any given dispute more or less suitable or more or less ripe for mediation without trying to prevent them doing so at any time. But look, really good comments. Thank you for those. And for those listening, please do put any comments in the chat or send emails to the participants. We're open for consultation. We'll take any further thoughts before we as the working group try and finalize this work product. But thank you, Lars and Shama and the IPBA for putting on this webinar as part of that process.
Thank you so much, Nick. This has been an extremely enriching 90 minutes. A lot of food for thought and action for the IASC and particularly our superb mediation working group. And with that, we will conclude the session. Thank you, everybody, all our panelists, all our attendees. Thank you, Lars, and wishing all of you a wonderful week ahead. Bye-bye.
Thank you. Bye-bye.
Thank you.